When I think of the merger and acquisition process, I think of it like selling a house. Well, everyone has a story of someone who walked in and threw down a pile of cash and said, "Let me buy your house." A lot of times it's a multi-stage process. First, we decide we're going to put our house on the market and we stage the house, we clean it up, we get some repairs done. Similarly, with a business, you should do the same thing. So once you think you would like to start selling your business, you should make sure all your legal documents are organized. You know where your contracts are. Your process and procedures have been cleaned up. The second step is what we call the letter of intent. And that's where you go out to the market and you get someone who's interested in buying your house or your business. And they put together a letter of intent that says under what business terms they will buy your business. A lot of times people don't use lawyers at that level, but I would suggest that in a lot of cases, lawyers can provide some good input into that process. Once you have a signed letter of intent, you go through what's called the due diligence process, which is where the buyer puts together a list of questions and the seller has to provide tax returns, financial documents, employment records, and other documents that the buyer thinks is relevant in order to evaluate the business. Once that process is complete, you then draft documents. Typically, it's an asset purchase agreement or an interest purchase agreement and other affiliated documents under which the buyer will buy and the seller will sell the business. Once that process is complete, we can now close, cash transfers, documents are signed, and you've sold your business.